Hey fellow viewers, welcome back to my channel. Today we are going to dive into an interesting topic, the distribution of powers between the central government and the states in India. It's a very crucial aspect of a federal system that ensures a balance between national unity and local autonomy. So let's break it down. In our constitution, we have articles 245 to 255 and schedule 7th that outline how power is divided. Also, if you are new here, make sure to hit that subscribe button and turn on the notification bell so that you never miss out on our informative content. Now, let's get into the nitty-gritty. The legislative powers are divided into three lists mentioned in Schedule 7th. We have the Union list, the State list, and the concurrent list. Each list contains different subjects on which the central government and the state governments can make laws. It's like a power sharing agreement. But wait, there's a twist. Many argue that the central government has more dominance over the state governments. This has sparked various debates and concerns about the need to reconsider these provisions in our legal system. To understand this better, let's talk about the concept of territorial nexus. Article 245 defines the territorial jurisdiction of the union and state legislatures. It basically determines where their laws can be applied. However, this has led to some ambiguities and conflicts as seen in the Republic of Italy versus Union of India. In that case, there was a dispute over which government had the authority to prosecute Italian convicts. The Kerala government and the central government had conflicting interpretations of the Maritime Zone Act. This led to a long and complex legal process, delaying justice. Such situations highlight the importance of minimizing ambiguities in our legal system to ensure a smooth and efficient process. Article 246 gives exclusive power to the Parliament to make laws for the entire country. This includes all states and the subjects mentioned in the three lists. The Union list includes subjects of national importance that are under the authority of the central government. Examples are defense, foreign affairs, atomic energy, banking, post, and telegraph. The state list comprises subjects on which the state government has the power to enact laws. Examples include police, local governments, trade and commerce, and agriculture within the state. The concurrent list, however, contains subjects of common concern to both the central and state governments. Both levels of government can make laws on these subjects. However, if there is a conflict between a central law and a state law on a subject in the concurrent list, the central law takes precedence. Examples are criminal and civil procedure laws, marriage and divorce, education, economic planning, and trade unions. Article 246A states that Parliament and state legislatures have the power to make laws regarding goods and services tax, that is GST, imposed by the union or the state. Parliament has exclusive power over GST for interstate trade or commerce. These provisions are in effect as recommended by the Goods and Services Tax Council. Article 247 of the Constitution empowers Parliament to establish additional courts to ensure effective administration of laws enacted by Parliament or existing laws related to subjects listed in the Union list, irrespective of the provisions mentioned in other chapters of the Constitution. Now, let's come on to discussing Article 248. Article 248 talks about the overlapping jurisdiction. Some subjects that were originally intended for state jurisdiction, such as industries, universities, and interstate matters, are now under the powers of the central government. This means that the central government can make laws and regulations on these subjects, even though they may traditionally fall within the domain of the states. It's important to understand this overlapping jurisdiction to grasp the dynamics of power distribution in our country. Article 249 allows Parliament to make laws on a subject in the state list if the Council of States determines it is necessary in the national interest. If 2/3 of the members present and voting support a resolution to this effect, Parliament can pass laws on that subject for the whole or a part of India. The resolution remains in force for a specified period, and if it is renewed, the law continues. However, once the resolution expires, any law made by the Parliament becomes invalid after 6 months, except for actions taken before that time. Thanks for watching. We'll continue rest of the articles in the next video. Stay tuned.